Is it on?
Yep.
Okay, so 6 o'clock, April 3rd. This is the April meeting of the legal committee. I'm just gonna take roll call. Ronnie, I see that you're on. Can you hear us?
I can hear you. Thank you. Can you hear me?
Dominic, Jenny, and myself, Margaret. We're also joined by Michael Hoffman and Tom DiPietro, and Crystal is online. Did I miss anyone? Linda, then of course it's on. Hi, Linda. Okay, so we had three laws actually that we were looking at. One was brought to the legal committee sometime last year. I think, Tom, you asked us to look at the vacancy law. And so in doing preliminary research into what the issues are and so forth, at our last meeting, we split it up that Gary and Ronnie would take initial pass at understanding what the opportunities were for looking at the vacancy law. And Jenny and I are gonna take a look at the formula retail. So in Ronnie's absence, Gary and I met with code enforcement just to get a handle on what the current law is and so on and so forth. So Gary, do you want to report to us on that meeting?
Sure. I'm sorry, thought I had a turnout of it. I don't. Margaret and I met with Craig and with Michelle to just get their input in terms of how they saw the law as it currently stood and the vacancy issue at large. And in general, here are just some notes that I have not reviewed with either Craig or Michelle, but I don't think I've gone off on any wild tangent. One item being that the unsafe buildings is part of this bundle, if you will. Craig had mentioned that that is under the jurisdiction of the state, and the code enforcement follows the state's regulations. So this is not an issue, as best as I understood, an issue for the city to concern itself with. The state law is very clear, and the code enforcement follows that. The vacancy law as it stands, Craig feels is okay from his standpoint, although in some cases, there are points that are vague, that may not address what folks think it really does. Certainly, that was my case.
Yeah.
We have to understand exactly what vacancy is defined as well as what it does and does not do. The law, we have to remember, was adopted pre-COVID and a lot has changed since then. Roughly, there are about 40 vacant buildings identified in Hudson by code enforcement. The definition of vacant building is a building, a portion of a building which is unoccupied and unsecured. Unoccupied and secured by means other than normal means. Unoccupied and unsafe building is determined by the code enforcement officer. Unoccupied and has multiple housing or building code violations is illegally occupied. For example, this law does not address buildings with locked doors, taxes are paid, and has been empty for years. So this is not a law that addresses what I would refer to as household buildings. The purpose for this law should be identified. The purpose of this law should be to identify any vacant buildings and make them inhabitable as soon as possible. And it seems to me that the partnership between Craig and Michelle is valuable to the city because in fact that's their focus. How do we get these buildings? And that should be our focus as well, I believe. Looking at this is how do we get? That's why we want to identify them. We want to register them. How do we get them back? And having habitation folks in there and do it within reason. There's a number of cases where buildings will be deemed vacant, but it's because of the fire. And the folks that own it have owned it for years, they just can't afford to fix it. So what do we do in those cases? So there's lots of issues that I think we need to look at in terms of, what's pertinent and what's important to us. And there's also aspects of the law that are difficult to enforce, such as when taxes are being paid out of a trust by the bank and the owner, perhaps that does not respond to the issues and the building is deteriorating before our eyes. So, you know, there's some things that we can look at and some things that we may not be able to do much of. And in the buildings where that were private residents, I already mentioned this. So those are just some rambling thoughts. I think what we need to do is say, okay, what are the real issues? Is this a priority? And what is it that we want to do moving forward?
So one of the things, you know, you mentioned the 40 buildings, but one of the things that Craig said was that of those, there are really, I think he said 8 that he would consider to be problem cases.
That's
That
right.
most of them were moving along in some direction.
That's right.
The lack of clarity about what, to whom the law applies. He indicated that, you know, a lot of people think, oh, well, that's just for developers, whereas it's actually applies to any vacant building. It's not just a law related to that.
And that's an important point. To Craig's point, you know, developers aren't going to allow this situation to develop. You know, they're gonna do what they have to do. So it's, you know, they're not running into this. This is, yeah.
And then the other thing that I recall, yeah, one of the things we talked about, was the issue of, permitting. And he's very clear that if you're not making progress, if you apply for an extension, they'll give you an extension, but if you have to show some progress. And you can't have a continuing, you know, extension after extension, that he is requiring people to apply for new permits after a certain amount of time. I mean, that's one thing I think that we could clarify in terms of enforcement. But I think for now, if you and Ronnie continue discussions with Craig to see, and Michelle, how it could be tightened up. He did not appear to think that there was any major concern, particularly since the number of buildings. He does do the annual report for Michelle, and the number of buildings that are problematic, is in the single digits.
So I can ask, how many, I mean, because initially when this was drafted, there was a purpose, right? So how many buildings right now are under the guidelines and consequences of the implied law as it's formed?
According to Craig, there were, I think he said 40, Gary.
You know, it's a rough number. I'll refer to the report that was produced for the city back in November of 2022, because it has a good breakdown. And they have, I believe, 35 buildings noted.
Michelle reported on it also earlier.
She did also.
I think
report.
before this council, last year, she reported on the number of vacant buildings, so it's in that neighborhood.
Well, I'm not talking about just the vacant building, I'm talking about, I mean,
There they stand.
well, there's a financial part of this. It was like, okay, if it wasn't, you got, I think it was first year, 250 bucks, and it got up to almost $5,000. You know, a certain timeframe. Where are we in that side of it? I mean, even if there's 5, at least 5, there's a template, but is there any of them, you know, utilizing the financial consequence to not having these buildings online?
That I do not know, because we were just getting an overall sense.
Okay.
I would personally like to get a sense of the history of this. This law has been in effect for 6 years.
Yeah, that's why I think.
Has it been effective?
No, I think if we don't have no numbers, financial numbers, okay, we got $100,000 because of this law.
Well, see, but I think it's also, we have to go back to what is the purpose of this law? And if is it to make money, or is it to get these?
No, the purpose
buildings back
was to financially incentivize
You're right.
them to get them online.
And it's
Financially by saying, if it's not done by this part, and what I'm understanding is that they're skirting that by paying a $300 permit rather than the escalating fee of not being unmarked.
But with the permit, Craig is addressing that by saying, okay, you're coming in for another permit, you haven't done anything, no, not
He's
yet.
not doing extensions.
Yeah.
So there are two separate things here, like one is kind of the situation, but he is requiring new permits if they're not making any progress. But I think it's a fair point to get a count of, exactly how that, and that was something that Greg did suggest that we look at the fee schedule, how that works.
Yeah.
Whether that made any sense, but I think getting those numbers certainly would be probably a good idea. Tom, I think you had your hand raised.
No, Gary sort of answered. But it was about, the fact that if you have a building permit, you don't pay that fee. And everybody had building permits. The law began, there are a lot more vacancies, a lot more empty buildings just sitting there, and a lot of them have been developed since the law went into effect. And then there was the myth of massive vacancies throughout the city, which really don't exist, I mean, there's vacant buildings, to be sure. I think some confusion was caused by various reports of vacancies that aren't technically vacancies under this law. But there's one, like you might remember one of the censuses, well, I forget what it's called, but it calls part-time, it calls short-term rentals and summer homes and all that vacancies. They're not vacant. That may have been some of the confusion as well, that people had thinking there were massive amounts of vacancies in the city.
Right, yeah, by the census, we have a larger percentage of vacancies, but it's not this
Not this-
vacancy that this law is
But
defining.
also, a very clear distinction is vacancy and unoccupied. So, a vacant building is one that has issues in terms of habitability. It's not secured in a routine manner. It's boarded up, or it's maybe unsafe. It's basically been tagged. An unoccupied building is one that is being maintained. There's nobody living there. And there may be many houses like that in Hudson, but they're not part of this law. This is specifically for vacant.
Can we not address both of those issues? Is that maybe a question for Crystal? Are those two things completely different in a sense that we will not be able to tackle those via this law? Because I think both of those are contributing factor to our housing issues that we are facing in Hudson. One,
Define the two issues that you're talking about.
I think, as Margaret has said, unoccupied is a building that is well maintained by the owner, but may not be housing people. Or maybe housing people for a very short time throughout the years, for like small percentage throughout the year. Is that correct, Margaret?
Yeah, that's pretty much it. So like if I chose to move somewhere else and I want to keep my house in Hudson and it's unoccupied, I maintain it, I pay somebody to do the yard, I take care of it, blah, 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 but I am not going to sell it right now, and I don't want to be a landlord, and it's gonna sit there empty. That's an unoccupied building.
Right.
And
then
that's not something you would typically address with a vacancy law, because the house it's not a habitable issue. It's not a safety concern. It's not like a zombie property. It's essentially a well-maintained vacant house.
Okay, no, I appreciate the clarity because I was under the assumption that we were trying to look at this vacancy law under the presumption that we're trying to, alleviate some of the concerns regarding the housing shortages in Hudson.
That was the initial concern, but didn't prove to be really,
I think, Ronnie, the problem is that, you cannot force a property owner to, become a landlord or to inhabit their property if they choose to have a property that they are not living in and that they are maintaining.
Unless it's
And paying
violations,
taxes. Sorry?
unless it's violations.
Right, but they're maintaining it, there are no violations, they're paying their taxes.
Right.
There really is no way to do anything about that.
I understand that, but what if a person or entity owns a bunch of properties and they're all unoccupied? I mean, Crystal, is there any way that we can address that?
They have good lawyers.
I mean, if you're looking, they typically they would. But if you're looking at a situation where there's not a safety concern, that they're not, open, it's not a, you're not inviting, people to come in. There's not much that can be done in that situation.
Is that like all the way like to the point of constitutional law? Like there is no precedent whatsoever that any municipalities can pass or, codify anything that could compel owners not to leave properties vacant for prolonged periods of time. For example, like years, or maybe like 11 and a half months out of the year, or, however they are skirting the law to, I don't know.
So,
Maybe I'm too far
Ronnie,
into
I
it.
won't say that there's no precedent out there at all until I actually do a dive to check that.
Okay.
I'm just saying that the vacancy laws typically aren't going to be covering that when you've got a situation where there are no violations and taxes are being paid and it's not a safety hazard and it's not, inviting unwanted, trespassers and things like that. But I can take a look to see if there's something like that where, so many months out of the year, whether there is any precedent for any sort of local legislation on that level.
Yeah. Okay. I mean, so what I understand is that that's going to be a separate issue. So we should, I guess, focus back in on the vacancy as defined by the law. Apologize for going on a tangent.
Chris,
Which I didn't. Well, no.
Chris, when you mentioned certain things, like I know there's a handful unoccupied by a certain landlord that the cops are always responding because someone's always in there. Now, is there something that we can put in this law if you have X amount of, calls or whatever, because sooner or later there's gonna be a fire, sooner or later something's gonna happen. So if they're not securing their building and that same property is being broken into 4 or 5 times a year, is there anything we can do and say, listen, if you have X amount of issues, it needs to be addressed or ABC?
Yes. So when you're talking about, because what you're talking about is securing the property and essentially police having to continuously respond for calls, just like we talk about with like the false alarm type situations. There are certain things that we could put in for that. What I would do is I would take a look at some other sample codes, pull what they're using and use that as a template, a starting point for that. But yes, when you're starting to talk about police being called multiple times in a year because this house keeps getting broken into because it's not properly secured, absolutely.
Well, if it's not properly secured, the current law addresses that. It will be deemed
It would be
vacant.
called vacant at that
Yeah.
point. It would be considered vacant.
Yeah.
Because one of the definitions include, that vacant house is one that is unoccupied and not properly secured or secured in an unconventional manner, like boarded up, etc. So if it's not secured, that would,
But being secured, not secured, and then also having X amount of calls to that because of not being secured, because I know of
But
at
it's
least 2
not secured,
properties
it's
that
vacant.
has not, this has happened in the last 3 months, the same 2 properties. So obviously, something's going on, right? They're not securing, but they're getting in because they're not securing well, or something's going on that they're getting into the same building.
if it's not secured, the definition in the vacancy law would term it a vacant property.
Yeah,
That makes it a vacant property.
but it doesn't mention the calls of service for police, not secured, but if there's constant issues of trespassers. Right, it can be not secured, right, you can walk past and that door's open, nobody's in there, right, that's not secured. But if that same property is getting broken into every other month from the same individuals, and they're utilizing it.
Dominic, are you proposing that we add language to clarify, for example, unsecured property leading to, nuisance of law enforcement, or I don't know how to word that. If Krista could chime in, but like repeated service calls, I think that's what it's called, right? Yeah.
Yeah, and you actually see situations like that with trying to think if I remember the code, but I know I've come across that before when you're looking at landlord properties, so ones that are rented out and where there are multiple calls to the property by police. There are code provisions in there that put a burden onto the property owner in those situations because of the number of instances in which police calls have to come out because of a property issue. So there is language that can be added in to kind of pull that gap between when you've got it locked and then you're also getting the police calls or service fire calls or whatever it may be
Mhm.
coming to the property.
Is that what you're asking about, Dominic? Like to add
Yeah,
that clarification?
Yeah, because sooner or later, because there's either gonna be, something's gonna happen, winter time, there's gonna be a fire, somebody's gonna start some, trying to keep warm or whatever. And maybe this also gives more data that we can collect of a certain property.
Yeah, that's fair. Gary, on the synopsis that you gave, you mentioned something about, I don't know if it was just off the cuff, about like Craig saying that, there are properties where, for example, there could have been a fire and the homeowner is not able to remediate that, and that's why it is vacant. If you don't mind refreshing me, the current law does not have any provisions or like time limits for like, because from what I would understand, if there is a fire or something, the insurance is somehow supposed to remediate that. So
We
we can't
talked,
just like, oh, I can't fix this. I'm just gonna leave this house vacant for however long.
we talked about the insurance challenges actually, and he had a couple of, specific cases of homeowners whose homes have become uninhabitable. There was one where there was I think it was like a mudslide situation.
Yeah.
Where the house, and they couldn't continue to live there.
And
But one of the things that he talked about was, the length of time for these people to get anything back from the insurance companies.
years.
And,
Yeah.
yeah, and so that's like, he has an issue with, issuing penalties to somebody who's not in a position to do anything to restore their home, and the insurance does not come through.
Crystal, that's another,
I think we can harmonize that with, I would imagine the state has some kind of, the state pretty much controls the insurance, if I understand how that part of the law works, right? Various states have different like requirements for insurance, and they have provisions where they can say like New York State would compel insurance providers to either accept or deny liability by a certain amount of time. And we can harmonize our law with that certain amount of time to like, well, this time has passed. Something needs to be done about this property. Am I kind of explaining that?
Yeah, there are timeframes in which an insurance company has to disclaim liability. Those sometimes can get pushed because they're all dependent on notice too. So it all depends on when they get noticed of what's happening. And
Yeah.
then there is an investigation that you usually will be, that's undertaken. And then the insurance company, based off the investigation, will then typically deny, disclaim or agree, or there's a long period of time for adjustment of the claim. So they may not be disclaiming, but now you've got, usually public adjusters involved as well as the insurance adjusters involved, and that extends the time. But there is, and it can be a bit extreme. Yes, the state has its statutes regarding unsafe buildings. Local municipalities can have your own local code dealing with unsafe buildings. The issue that usually comes there for the municipality, though, is that at that point, you're going to issue a note. Once you've got an unsafe building for a certain period of time, you give essentially a due process right for someone to come in and be heard on it. And then you have options, and your options are never great for the municipality. It's, either demolishing the building at your own cost and then charging it, going after the homeowner for it, or putting it onto their assessment, or trying to remedy it the municipality self. And it's never a cost that governments really want to take on a regular basis. But it's something that most governments, and I would assume I'd have to go back, look at Hudson's. I would be surprised if we didn't have a statute that speaks to that at some point or in some level.
I mean, like, I understand what you're saying, like, punishment can really only go so far to remedy a situation. I think our role should be to, try to encourage vacancies to not exist, or to encourage vacancies to be remedied as soon as possible. We can't, like you were kind of alluding to, we can't punish homeowners to the point where they're dealing with, let's say, insurances and the municipality, or we can't take over a property and demolish it. That's not really the intent of anybody, I would imagine, on this board.
Well, you
So,
can, but it's expensive too. So that's the other
we
issue.
we don't want to go that route. The route that we would rather, well, at least in my perspective, that, as a city, we should be trying to encourage homeowners and facilitate, in a way that.
I'm sorry,
Sorry?
that is the intent of the law, and we do have an exemption clause in here, but to your point, Romney, we have a 90-day after the date of fire or extreme weather event, to submit a request for an exemption. But we probably can do a much better job in harmonizing it to the state regs as well. So, yeah.
I would tell you, the last couple times I know that happened where the city demoed it, they never recovered their money. Because the land got sold for less than that recovery was there. So even though that's an option, there's no way the city's gonna get their money back.
Now you open up this, this is just a discussion for what ifs, because I know cities that are much larger with much bigger housing stocks, they will look at the bigger picture, where sometimes demolishing a property and selling it at a loss, with the caveat that the new landowner has to develop on it within a certain period of time, is actually in the long run better. We're not going that route, I don't think. I'm sorry?
No, I'm agreeing with you.
Yeah, I don't think we're going that route, because I don't think Hudson has that big of and we don't have that kind of resources at our disposal to be able to, write off.
And also bear in mind that as of the most recent conversation, there were only approximately 40 properties that were vacant.
And when you start breaking a number of 500 permit and
Right,
moving
exactly.
along,
I know,
there's only a
and
handful.
of those, the estimate was 7 or 8 were problematic. So we're not, Tom has his hand up.
Wasn't a big part of this law originally that they have to register, and it was registration?
Yes.
Identify, register.
So how many are registered? That's.
I think that's the number. I think
35 to 40,
Yeah,
Oh, okay.
that's right, because
Actual
Craig
registered.
does an annual report on it.
Yeah.
So Chris, you mentioned insurance, and I didn't remember seeing anything in this law, because technically, a homeowner doesn't have to have insurance. In
They
the
do
city.
not. That's the
Right.
other thing. They may not have insurance at all on the property.
So is there a part of this law, we can say they have to carry insurance, because again, that's, if something was to happen to
State
them,
level thing, I think.
it's gonna affect the whole neighborhood possibly.
I don't think you can require people to have insurance.
If it's under the vacant, if it's if their property is identified as under these
Okay,
things.
so if I have a property that meets criteria to be termed vacant, AKA not habitable and not secured in a efficient fashion, I am not going to be able to get an insurance company to write me a homeowner's policy. Not gonna happen.
At the same time, I don't think we as a municipality could require insurance. I think that is a state level thing. I could be wrong, but.
So I wanted
Yeah.
a couple of other items. So next steps on this, Gary, I think is you and Ronnie, taking it based on the discussions, with Craig, some of the ideas, looking at this, the fee schedule, that was one thing he thought we should look at. And just, I think, getting, numbers on, like, how much has actually been brought in, like, how many people are at that 4,000 or 5,000, that we get some concrete data on that.
Mhm.
And then we can report back on it next month. Does that sound reasonable?
Yeah,
Okay.
I'll try to see if Craig has any availability on Fridays, so I don't have to take like half a day to meet with him. That was the reason that I couldn't join you guys.
So our next item is the formula retail law. So this law, that's my folder here. We had been working on this law last year. Specifically, when I first started looking at it, to put in a point in time, because it didn't have anything in it that identified the point in time at which a business had to be in compliance. It was kind of open-ended. And so we had a couple of instances of businesses that opened where the store that opened was greater than the fourth location for that store. And so my understanding of the history of this, going back to 2018, was it was really focused on character, and that's how it's described as character, to prevent a change in the general character of the downtown by having any basically chain or formula retail coming in, or formula business, not just retail, but businesses. And so that was the original intent. And so when we first looked at it in legal committee, we really just focused on trying to identify a point in time where an applicant or a person who's going to open a business has to be in compliance. The initial thought was that that would be when they do a building permit, but then Craig pointed out that not everything requires a building permit. Not everything goes before the planning board. So one of the things that when we brought this forward, there were a couple of people from the business community were at the legal committee meeting, and they raised a number of questions about it. So rather than moving it through with the new timeline for when you have to be in compliance, we thought we'll take it back and have another look. So one thing that's come up in the discussions is coming up with a process where there might be some licensing or something like that. Take it away from, are they going to go to code? Are they going to go to planning board, whatever? But actually any business that's going to open has to go through some kind of licensing or permitting process. And at that point, at that application, they would have to attest that this was not greater than the fourth location for their business. So I think we're in agreement on that.
I
right,
think
Jenny?
so. I think we should issue a business permit, not necessarily a license.
Permit, right, that's, yeah. So that we could do. So then Alex is here, and the Business Coalition had a number of observations and comments. So we have, that was distributed to everybody. Let me see, I've got the right one here. Okay, so you want to, Alex, just give your perspective from the business community?
Sure. So, as Margaret indicated, as we understood, the original intention of the law was for the preservation of character among the business community. We took a look at the law itself last year until early this year. The issue of timeframe was important, but we also recognized that the agencies and departments mentioned in the law, planning board, ZBA, and code enforcement, not necessarily every business would have to go, every business would not necessarily need to go before one of those, which may allow some to sort of slip under the radar. Coming up with either a licensing or permitting process would be helpful for that. We also identified, these sort of potential edge cases, meaning that if a business were to move locations, close for a short period of time to do renovations, things like that, there's a way this could be interpreted that they'd be out of compliance, so making sure that we close any potential.
Sorry, can you say that again?
Yeah, so I made mention of this in the recommendation, so we don't want to penalize business owners who open here, achieve some level of success and subsequently
Right.
expand beyond Hudson. first and foremost, there's a way you can read this, if that a business were to open here, expand beyond the
Right.
number, and then have to go before.
That's explicitly not in this law.
Right.
But the whole point about identifying a point in time where they have to be in compliance at the point of application, right? Is in this moment, this is what it is. The future is the future, and this has no bearing on the future. So there is nothing that prevents a company that maybe started out here becoming wildly successful and being the new LL Bean of the future.
Mhm.
This is only about, at the time that you opened here, was this one of no more than 4 outlets?
Right, and there have been other instances where a business would move locations within Hudson. Would then be considered out of compliance if they had to then subsequently go before code enforcement, the zoning board of appeals. So let's imagine that a business.
Say, okay, so you're saying, when I started here, this was the second store, right?
Yeah.
And then I expanded in other places. Now I have 6 or 7 stores in
And now-
other places. And now I want to open a second Hudson location. Is that?
A
the
second
same?
Hudson location, or you're just moving within Hudson, you're moving from Lower.
Oh,
Wall
I
Street
see what you're saying.
Street.
I see
Now
what
I
you
need to go back to code enforcement, or zoning board of appeals, or whoever else, one of the mentioned agency.
But they
here.
would already have a permit to do business here, so
That's-
they
To
could,
be
But
a
we-
specific address, though.
But I think we should make that explicit,
okay.
that if you're just, changing location, like Talbot and Arding, for example.
Yeah,
If they had 5 other outlets somewhere else and you
Yeah.
moved from Warren over to there with this, that, I think we can clarify that.
and, you know, if there is that permitting, it would have to be, I would assume it would be associated with a single address at the time that they apply for that permit. So again, if they were to change address and now have to, change location, then have to reapply with the permit issued for that business, regardless of where they are in the city, or just at a specific
Okay. that's good.
address.
Along these lines, could I throw out a scenario, and it's an extreme one, but, I hadn't read the rules to say, I had read that if you started in Hudson and then expanded elsewhere, we don't care.
Right,
That's correct. But we're also saying if your second store is in Hudson and you have 10 more stores afterwards in Columbia County, all looking the same way, we're okay with that.
Yes, we
Well,
don't control the future.
Don't control the future.
You cannot.
are you, just so I follow you, are you saying if, business opens here and then opens additional locations within Columbia County?
Yeah.
Yeah, I mean, I think that, again, it's more to how we incentivize businesses who want to open here, who want to come here and start, making the most attractive environment for them. I think if they do achieve that level of success, I think it's then challenging to impossible to get them to change should they, you know, and expand beyond the borders of Hudson, additional locations. I think that, you know, really it's about it, as Margaret's identified at the time that they're open.
So, and also, Gary, this isn't just about Columbia County, this is anywhere, this is
Well,
number of stores.
I was making it,
Right, right,
you know,
right.
very simple.
Right.
I mean, you know, there's also, you know, what if someone comes to us and they have a store in Paris, Rome, Florence, and San Francisco?
They have 4 locations, they can't open here. That's how it's open.
So basically, it's like, we're the first rung of that ladder, but we can't be the 5th.
I understand this fully, and, you know, I guess I'm getting to the point where what does this have to do with character of the city?
I know,
I'm sorry.
the language in it says in the world.
I saw that. And so, you know, I mean, again, going extreme, what if someone, you know, has 4 stores in Bangladesh and wants to open one here? I personally think that adds to the character of the city, but I'm using extreme.
Yes.
And I'm not sure if what we're talking about here really is about promoting the character and uniqueness of our district.
Gary, I think from my standpoint, when I moved here, I really loved this place because there was so much creativity
Mhm.
among the local businesses. And, you know, things have changed since then. And now it's not as affordable for people who are creative to start their own business. But I do think that if you already have 4 businesses, the character of your business may become slightly formulaic,
Uniform?
uniform, formulaic, and maybe that's what we don't want.
That's
We don't want something that's,
But we're saying we don't care about color schemes or decor.
oh, I do, I
But this
care.
board doesn't.
Sorry, say that again, Gary, don't care about what?
This board doesn't care about the decor.
It
The
does.
language that was stricken by Alex,
Well, it was suggested.
yeah.
You know, these are suggestions.
Okay, yeah.
These are- No,
But-
Yeah.
the markup that you have are suggestions from,
Yeah.
right? So part of what we have to talk about now, there are things that, you know, Jenny and I, when we went through this and looked at your recommendations, we would not be in favor of removing the language relating to the core.
So,
Or branding of any kind.
Yeah, because we feel that that is like quintessential to the law is the formula piece.
yeah, so to that point, I understand fully the point you're making, and Gary, to your point, you know, we turned this over for a long time, in discussion, right? We thought about all possible angles as far as drawing a radius around Hudson and saying, you know, inside, outside that radius for a number of locations. We really investigated it from all possible angles, and what we kept coming back to was the number of locations as the thing. And there was, quite frankly, some disagreement on what that number should be, but ultimately 4 sat with the group as being the right number. To Danny and Margaret's point, there's other criteria that's listed within the law as it currently stands, having to do with signage, uniforms, having to do with inventory, so on and so forth. All of those things we agreed are important for purposes of defining a formula business. The reason we recommended striking them is because at the end of the day, the defining criteria that the law lays out, both in its current form and what we're suggesting, is number of locations. It all just sort of comes back to that. So in strengthening the law essentially, which was the original remit of this, doing away with those additional criteria doesn't weaken it in our feelings. It actually strengthens it because you have the locations as the thing.
What
as
does
the
it mean I
criteria.
have, okay, but here's the problem I have when I was trying to figure through what you were suggesting. I got your point that when
Yeah.
it comes down to location. So what if, I have a diversified portfolio
Mhm.
and I have, 6 locations and no, they're not quite the same, et
Sure.
cetera, but it, you know, I have all of these things going on. That's fine for me to open a store on Hudson as my 7th. They're all kind of interrelated, but they don't look the same. So if your thing is, if you have, we don't want to go into formula and branding and so on, it's just too many locations you have. I, as a sole retailer, actually have 7 locations. They don't look the same.
Mhm.
You would say you have 7 locations, therefore you cannot open. I have, you know, when you strip away the
Margaret,
language.
Crystal's trying to chime in, and then I am too.
Sorry?
Crystal is trying to chime in. She
Oh,
has her
sorry,
hand
okay,
raised.
go ahead. I don't have anything up. Go ahead.
So there's actually really important and valid constitutional reasons why you want to keep in some of this language when it comes to branding and when it comes to its, the branding's effect on community character. Because what you can't do with this law is you cannot make it so that you are favoring local businesses as opposed to national businesses. So that's important. You do that and you start, getting to the point where you might have challenges and be overturned. So that's why you'll see, if you look at these formula retail laws, not just in New York, but throughout the entire country, and the challenges that the ones that have been challenged, what you're looking at is they have to focus on community character. They have to focus on the type of standardization that you're trying to avoid. And exactly what you were coming to, Margaret, is that, you could have someone that's got, 6 establishments out there that might all be a little bit different. And really what the purpose of these types of laws are supposed to be is to be preserving how this community looks and feels. So just because there's 6 establishments out there, if they're all a little bit different, it doesn't necessarily mean they shouldn't come into Hudson. So you really do want to keep these types of branding and community character portions of these laws. That was my 2 cents.
And then I had some thing that I've been trying to add as well. In our initial discussions, I think I brought this up, is that from what I understood, the formula retail laws in other municipalities and even us, we're trying to tackle is that we don't want this like prepackaged store in Hudson just popping up like, 20 different types of prepackaged things. And it just basically looks like any town in America at that point. What we want to encourage is businesses adapt to, like Crystal said, the community character of Hudson. We want to encourage businesses to develop within Hudson organically. But at the same time, we don't I still feel that let's say, Dunkin' Donuts wants to open a store in Hudson. I don't think we should be they cannot. I think we should have language in there that compels them to open a store that is in line with the character of Hudson, that preserves that small town mentality and it's not formulaic. And that's why we're calling it a formula retail law, right? That's what I was thinking originally. But if we're still going with the number and quantity, I think it's
Ronnie, the formula piece that you're talking about with regard to Dunkin' Donuts, that is exactly how certain of the fast food restaurant chains have opened in municipalities with really strict laws, is that they have to open something that does not look and feel like their chain. It has to fit in with the community, and they have to do that.
And that's why the branding portion of this is so important.
And I don't think we should discourage that. I think we should encourage, we're not gonna say we don't want, personal feelings aside, we don't want, a certain business to come in. We want to preserve the small town feel of Hudson while still encouraging business. And our Hudson Business Coalition partner can chime back in. Our intent's not to discourage business. It's to try to preserve the charm of Hudson as much as possible.
Yeah, if I can respond, so I think that, is it Crystal, the attorney?
Yeah.
Crystal, your point was really well taken, and a big part of this, we're presenting our recommendations.
Yeah.
Right? We don't have any attorneys
Yeah,
writing as part of this discussion until now. So hearing that obviously factors in greatly, and understanding that I don't know what the term is, but the admissibility of the law itself, long-term, is obviously going to be somewhat dependent on these additional criteria. So I would say that, I don't know where the committee thinks we are in this process, but if we have an opportunity to look at those additional criteria again, figure out, how to structure it with the number of locations plus some number of criteria that would have to be met. I think right now it's 2 out of that.
There's the 4+ language, and then at least 2 of the following: standardized array, standard facade, standardized decor. So if 2 of those plus 4+ are met, then that's a formula business.
Right. And now are we imagining that those are evaluated at the time that
at that moment, and I think the thing that I think it probably came up when in the meeting where some of the business folks were at the legal committee meeting at the end of the year. I think the idea of having a separate process, you're opening a business, you need a permit.
Right.
And then at that moment in time, you're evaluated as to whether or not, and that these code enforcement out, you're evaluated as to whether or not this is compliant. If it is, great, and then you
Yeah.
draw a line, and we do need to clarify, I think that that permit is associated with the business.
Yes,
So that if I move from Warren to Allen. and I
It doesn't
move
matter,
my
it's
business,
attached to
my
your
permit is
business.
For my business.
Now,
Can I-
now,
Sorry,
Yeah.
can I just make a recommendation on that part?
yeah.
Because this has come up, I think, in just more than just this formula retail law. I think the idea of like a commercial license has come up before. And I understand wanting to keep it, business specific, but there's a good reason to actually make it, business location specific. And that's because when you've got like a new business commercial tenant coming in, it requires them to kind of check off check the boxes that there's not like a code enforcement issue or a violation on that might have been an oversight, and that fire is up to snuff and all of that. It's usually a pretty quick process, doesn't require planning boards. It can all go through the building department process. But it makes sure that that location doesn't have any issues like code issues too when they're moving in. So it's something to think about. I can send over to the committee after the meeting, samples of other laws that are like that in other municipalities where it's, whenever you're going to go in and you're going to open a new business, if it's a new business in that location, it wasn't what was existing there, they got to apply for a commercial zoning permit. And it's it gets signed off by fire, gets signed off by code, and then you're good.
So, Crystal, one of, the idea of the permit, as I was thinking about it, was so that we could divorce it from the code enforcement piece. But anything opening, if they're making any changes, whatever, they would all still be subject to code. And if I was moving my business to a new location, code enforcement would come in and give me a work permit depending on what needed to be done. And they would sign off on it before I could move in, right?
Not if it's turnkey. I talked to Craig about this because this has come up in other contexts. That if it's turnkey, no, that doesn't necessarily happen. And that's where there have been questions about whether is that something that Hudson wants to do for businesses to make sure that it's not just a turnkey where code's not aware of what's happening on it.
Okay,
Yeah. So if literally all you were doing was getting shelves for your merchandise, you wouldn't get a code or something.
No, but you move.
So.
So Crystal, if you send us some examples, that would be good.
Sure.
But we could still put some language in there that, it protected a business that is moving and like, we have to redo the permit, but you had an existing permit. Yes, you now have 10 other locations, but you are a Hudson business and you met the criteria, so we're still going to carry you.
You were previously issued a permit.
Yes.
Checked out.
Yeah,
and now you
yeah.
Would you envision checking compliance when the application for a permit is?
That's what I was gonna ask.
And, I mean, I've not done this, but could I easily enough find out that, Joe Smith has 10 other businesses
Well, I
under
think-
different LLCs? Is it easy enough to do that? Right.
I don't think we care about the individual having multiple businesses. It's individual having multiple businesses that look exactly the same. That's the issue.
Yeah, right.
Yeah, that's it.
So I think we did talk about this, I think, Crystal, when you were drafting the penalty language on this. So this is a good 6 months ago. So if they attest that at this time, they do not have more than X number of either businesses currently open or in the process or applications in place. And then after the fact, we determined that, well, actually, that wasn't true. There was a pretty substantial penalty in the law as you drafted it, Crystal, as far as I recall. I mean, they are attesting to this.
Yeah.
They're signing
and
it. True.
I think it goes as far as closing the business too, like pulling their permit and ability to operate in the city. Yeah.
I believe it did, yes. So there are penalties, but I mean, you're asking somebody to attest to something as a fact.
Joe, willing to close them up if they lie.
If they lie, then there's gonna be a penalty.
Okay.
I'm good with that, follow. You submit something to the planning board, and then build something different, they can shut that project down, same principle.
Yeah, good. So I think that's okay. So I think the takeaway on this, and I really appreciate the
Sure.
time and effort that the business community spent, is we will work on a revision, we'll work on something relating to the permit process and covering the issue of a business that relocates, within the city. I think, is there anything else you want us to make sure we're
The
paying
only other
attention
thing
to?
that came up in discussion, that wasn't sort of set as a carve out in the initial law was for, real estate agency offices, so because many of them have multiple locations, they don't really fit into the other criteria as far as, you know, they don't wear uniforms for the most part, and things like that, but that did subsequently come up among our board following the discussion that we had about this. That was one, I know there's carve outs for gas stations and for pharmacies, which makes sense.
Yeah.
But for realty agents, it seems like they could potentially be subject to this and we shouldn't necessarily want that.
Okay. So we'll
I'm
just.
totally fine with not having national realtors be operating in Hudson after what we've read about in the recent news.
I think they bring them in a little bit, so.
What happened in the recent news?
There's some new regulations for.
Some
real estate.
big named national real estate related companies colluded to inflate prices so they could profit more. Millions of dollars were paid in fine.
But remember that this law is not going to be designed to keep out national businesses. That's
No.
important. It's important to note that.
This was just a comment that's unrelated. to
It's
this law.
actually, yeah, but coming back to what Chris said, it is about formula. So in the instance, so for example, you have a national realtor. And I'm an agent with that company. But my storefront in Hudson is not gonna be like storefront in Philadelphia or Kinderhook or somewhere else. So I probably wouldn't meet the criteria as they're set out to be called a formula business. Because I don't have everything the same decor, same look and feel. You know, I've got my little real, in this
You got
town.
your branding.
Yeah, in this town, yes, I'm ABC National Real
Yeah,
Estate
because they
Company,
don't have any.
but I'm in a little house.
Right.
And then in another town, I am, because of the nature of the town, it's gonna be ABC National, but it will be in a shiny building.
I see. So you're saying, Margaret, that there wouldn't be a carve out
Wouldn't-
because they wouldn't fall under.
Cause I don't think
They
they
don't meet
meet,
that
they
criteria.
don't meet the formula
Yeah, that's what I mean.
definitions, right?
Okay, yeah. That makes
Right?
sense to me.
I agree.
Yeah.
Okay, all right. So I think that's what we got on formula, right? I'm hoping the film, hoping the film law piece will be short. It's 6:57.
I didn't realize this was.
Yeah,
Okay.
I do have to drop off the call at like 7:15.
Thank
Not
you.
right now, 7:15.
Okay.
Oh, okay, so film. So I guess, this, what went actually to, I wrote down the date that it went. This made its way to the full council. And was out of, like in January, I believe. December 18th, there were some revisions made. And Theo was not gonna be around for going to the full council. It went to the council, I think, in January, to the informal. I don't think it ever got voted on.
Yeah. I can't recall, but it was, right, because the other changes that we had to post for this one.
Right, he made changes on December 18th. And then it went to an informal in January, or February. I don't think it was voted on. So there were a couple of things, that, well, I don't know the rationale for this, but you are recommending that we include, still photography, particularly if it's promotional adverts, so that should be included.
Yeah.
And in the version that we had in December that went to the council in January, it explicitly excluded still photography. But you are making a recommendation that we include commercial still photography, is that correct?
Well, we recommend, so a little bit on the process, we created a totally separate group. We included location scouts, advertising people, photographers, videographers to weigh in on this and sort of compile their recommendations. Part of those recommendations included to extend this to still photography shoots in addition to video. because in some instances, those can be as disruptive as video shoots, and it's also seemingly the majority of shoots that are occurring right now in the city of Hudson, again, according to the individuals who do this work on a daily basis.
Yeah, when I saw that, I thought that was a good addition to add that. But then I went back to the version that went to the council in January and it explicitly said still photography was an exemption. And I don't know if anyone has any history of, I wasn't involved in the development of this, so any reason why originally still photography was explicitly listed as exempt?
Partly because it'd be very hard to enforce. Someone with a phone can come up and take a picture. And has anybody,
But I think if we frame it in terms of commercial still photography.
still, you mean, you would then have to identify a full use of equipment? I mean, how would you identify it?
That could be where you're getting into crew numbers too, like a photo shoot requiring multiple people. There had been that conversation about for, very small crews, like 2 people, to actually exempt it, because it's not going to be an interference at that point.
Right. Exactly. So the same way we're talking about other criteria with the retail law, there'll be other criteria to baked into this, which there seems to be now, but we can dig into that a little bit more. But yeah, it's mostly about, avoiding disruptions, right? Ultimately, and whether that's still or video, that can happen either way, but you're right, Tom, that in fact, more factors, weigh into that, than just the second.
So maybe if we come up with some language here around commercial still photography with a crew of X or more.
So what happens if a photo club comes in?
That's not commercial.
It's not commercial.
How do you identify that? If there 3 or 4 people come in, how do you know they're not commercial?
You just ask them who they are.
Yeah.
You haven't seen some of the YouTube things I
Well, if a photo club comes in, they're all going to have cameras.
Yeah.
And if you have a commercial crew coming in, they're not all going to have cameras.
Yeah, right.
A big component of this was the noticing, which I know was in the law initially, but again, having the folks who work in this and who do this quite frequently, they had some additional recommendations on how best to circulate notices, when to do that among what contingent people, things like that. And we provided a sample letter that's commonly used.
Okay, so we can do some more work on this. There's one thing I do want to point out that because I do remember the discussion as to why we made it this way. You wanted to change something to it's under section C under where are we? It's the language around any change in the applicant's planned activities, etc. Shall be submitted in writing to the mayor or their designee at least 1 business day in advance. The reason that's 1 business day and not 24 hours is because there's nobody here on the weekend.
Okay.
So if they make changes on Saturday morning for something on Sunday, there'll be nobody here to review. So that's why we made it a business day.
Makes sense.
I have a question, on 132-3 permits required exemptions. 132-3 permit required exemptions and, section, there's the item D. Any entity that is producing a film or films or still photography for purposes of promoting Hudson, New York. I could see anybody using that argument.
This is new. This is a recommendation from the business community. So again, you're looking at a markup of the law that went.
Okay, that's, I'm not sure who is making these comments, sorry. Well, anyway, I think we need to say the sole purpose of promoting Hudson, New York.
Yes.
Because if I'm making a movie, a commercial movie, I'm promoting Hudson.
Yeah,
Right, that's good.
exactly.
I didn't understand the rationale for any business or entity that is based primarily in Hudson. Why would they be exempt?
That was exemption for the fee, not
Fee.
for the permit itself.
But to
Oh,
your
for the, I
point,
see.
this is about disruption,
Right.
and disruption is disruption.
Yeah,
So,
sure.
you know,
And it's
if we want to give a break to our,
incumbent businesses,
Yeah.
yeah. That was for the fee. So two, under that, Margaret, B two, I guess, a film permit should be
Yeah,
completed and submitted, but without a fee. So
without a
that's for, again, anybody who's promoting something, promoting Hudson as a destination, and then any business renting that is primarily based within.
and you also made the case that it shouldn't be at graduate level or,
Yeah,
graduate
that seemed arbitrary to us. I don't know.
I can't remember the rationale for that, but I agree with you.
I do too. I mean, I'm sure they're doing it in
Yeah.
middle school today, you know, appropriately so.
Yeah,
I liked the suggestion regarding aerial drone photography.
yeah, that's a big component.
I thought that was very good.
And that's common as well to file a flight plan with, especially, you know, there's, state hospital and the emergency helicopter services, so.
I have one other item, if I could bring it up.
Yeah.
And this isn't a comment, this is in our, in the law as it stands currently, 132-5, the filing of application. On section D, film permit applicants for activity involving 50 or more persons in a public area are not required to additionally submit a mass gathering permit. I'm imagining, I don't know, that we would be looking for a lot different information in the mass gathering permit than in a film permit.
Yeah.
And so, I'm not sure if it's cool that we say you don't need to go through the mass, gathering permit. If we're capturing the same information, fine, I just.
I think the part of the mass gathering, because all players sign off on the mass gathering, police, fire and everything. So I think that that's why the mass gathering permit has that number, but I still think there should be language in there that they have to have, you know, the sign off, like similar to mass gathering.
I agree.
Right?
Will they be charged twice then? I'm just,
Well, that's a good point. There are fees associated with both, aren't there?
132.5, you're saying?
1325 D. Yeah. So I think the rationale here, if I'm understanding, is that the information would be captured as part of the film application itself, and thus doing the mass gathering that you're done.
Yeah, I worked on this and I put that in there specifically because we felt it would be duplicative from also fill out a mass gathering permit that has effectively the same documentation requirements.
Same
So-
language?
Right,
It requires the same information.
which is what we're using right now. We're in the absence of a film law, we're using the mass gathering permit for film activity of this
That's
size.
good. That's all I want to make sure.
Yeah,
So we go back to that promotions, and so when it says promotion, so for example, if a father and son who has a YouTube page, and they go and do a travel video and go all these different places, and they stop in the Hudson, and they, you know, are photographing and videotaping all the businesses, they're exempt from any kind of permit, right?
Well, that's, I think, a good question, because as influencers, they could be making $1 million.
No, absolutely. No,
Right, yeah, and someone had mentioned in someone that, you know, how do we handle influencers here? And I don't know. You know, if it's about disruption, are we saying it's not a group of 5 people?
if they're
I
not,
think enforcement of influencers is gonna be extremely difficult. I think you're putting a big burden on the city by trying to enforce that.
Well, we got First Amendment, we got public, where you can, that long-term public, you can film where you can see kind of deal. So yeah, I think there's a big hill.
I think if we focus on commercial, still photography, big picture stuff, actual, commercial as opposed to charity movie making, things that are not solely promoting Hudson. If we focus on those things and then get it out of mass permit land where it is, add the drone thing, because that is a big deal, I think. And the reason everything was linked to the mayor, the mayor's office does mass permits right now. And that seemed like the reasonable location for it, because if you just say, that was one of your comments, if you just say City of Hudson, who in the City of Hudson? So the mayor's office or their designee would be the appropriate venue.
Yeah, I think we agree with that. I think it was just language that said it was up to the mayor's discretion, you know, whether or not to grant the application, and we felt that if they met the criteria, that it should just be granted, you know, without having, you know, the mayor or one of his appointees saying yes, you know, evaluating yes or no, whether or not, you know, if you meet the criteria, you meet the criteria, right? Granted.
I think the concern was that we were giving the mayor some kind of leeway to evaluate individual circumstance.
I mean, you could.
More likely the mayor is compelled by the law to accept the, you know.
Right.
That can be too.
But it doesn't, it empowers the mayor to stop something huge from coming into the city and that is unreasonable.
Right, exactly.
Or coming in at a time where we have something else going on.
Right.
And yes, you met criteria if this had been October, but you're trying to do it in June when we have something else going on.
Yeah.
So
It's mostly for like a unforeseen, like the law was not able to foresee this huge issue. And the mayor can have that discretion.
Sure, makes sense.
Michael, what was in play when the Today Show came a couple of years ago? What was that one?
You know.
No.
Nothing really?
Mm-mm.
Wow.
This is why we're doing this. Because if you don't hit that 50-person crew threshold, we have nothing on the books that requires you to do any permitting for filming in Hudson.
Okay, so we will do some work on this and hopefully get it to the,
Did you see Crystal's written response to the thing?
Yeah.
Okay, maybe we should forward that.
oh, okay.
For example, the penalty language is a standard.
Okay,
To send them.
So-
Yeah.
under new business, I did not put this on the agenda and there are no documents associated with it. At one of our last council meetings, there was a resolution which then didn't go on the agenda relating to, increasing the lodging tax in the city. I just want to bring that, I know that everybody on the council, I think, got the initial draft resolution, just want to bring that forward. And I know, Alex, that you had some thoughts on that, tax resolution increasing the city percent from 4 to 5%.
Yeah,
Yeah, so, yeah, go on.
just that we were hoping that the lodging-based businesses would have an opportunity to weigh in before it was voted on. Not that we had a specific position at this time, but that they would have, because they're the ones, obviously it's paid by people who stay, but they're the ones who
Right.
pass on the tax to, City of Hudson, you know, the lodging tax for that. So I don't know if is this coming up further at the next informal meeting?
I don't
It's
know.
coming up next and formal, and there is a certain, in order to be approved by the state, we have to get it done in a certain amount of time too.
Okay,
But the argument will be made in informal, why we're doing it, well, you know,
yeah. we can-
I would encourage some of that meeting rather than, you know, some special meeting with lodging tax people, I mean,
Lodging group people, yeah.
industry people. The county voted to have their 4% tax. So as it's, and we're not part of that.
Mhm.
Why are we not part of it? I thought.
Because then we would have, yeah, we got it up.
We opt out, right?
And we'd have 4 for them and 4 for us, would be 8% tax.
Right.
So the county did pass it,
Yeah.
but the city is not subject to that, that's
So
all.
we only get our 4%, but the county don't get anything in Hudson.
Correct. Okay. And if we
Stays
raise
here.
it to 5, excuse me,
It stays here, right?
yeah.
Yeah.
If we raise it to 5, I don't think people will stop coming to Hudson to go to. the
Yeah.
county.
I have a question. Is
Yeah.
this, is the lodging tax for both short-term rentals like Airbnb and the hotels?
Yes.
So,
Okay.
Oh, yeah.
Okay, okay.
Very good.
So, you know, I know you had pulled some stuff together. I've been looking at other locations and looking at other municipalities that have, the higher, because there's a process you have to go through to go higher than 4%. And interestingly, Beacon, has, I believe, a 5% for the town. They also have a 4% county, and then they also, of course, have the state tax,
Yeah,
which I thought was kind of interesting.
exactly. That was in the document I was gonna circulate to the council. There's more other places that have both the city and the
Yes.
county,
Yeah,
and they're upwards of 9%. So we're not really looking at we were looking at an increase.
I did find a number of them that had both county and
Correct.
municipality taxes.
And New York State legislature has.
But state is gonna be state, that's gonna be the same across.
Yeah.
Well, wasn't it, so the county, they're 4%, but they go to all the little towns and everything.
Mhm.
Right, so wasn't there some kind of component that if we got rid of our 4%, they were gonna do like a 5 or 6%, but we were gonna only get like 2%, right?
But we wouldn't want to do that because.
No, I know that. I'm just saying.
I don't think that would ever happen.
Yeah.
No, I'm just saying, I thought that was, they were.
Yeah.
The only,
I-
well, I mean,
Wish I could have been part of this conversation. You guys really started something interesting, but I gotta go. I'll catch up with the recording and the, notes. Have a good night.
thanks. Have a good night.
To Margaret's point, if we go to 5%, we're still not encouraging people, it's not like people are gonna go to Beacon instead, because, that's 9%. You know what I mean? It's like,
Well, Beacon's really nice. I love that.
Yeah, I didn't
I
want to say
love
that.
that art museum.
Exactly, the Beacon is fantastic.
The Dia is fantastic.
Yeah,
So,
one other thing I'll mention is that when the law was passed, obviously some amount of that revenue was allocated to help bring more choice.
well, yes, initially,
That
that's the,
has changed with
that
the
has
previous
changed.
iteration of the common council. I think, the lodging tax revenue may say otherwise, but we are seeing, especially when speaking with some lodging businesses, we are seeing a softening in visitorship right now over the last 12 months. Right?
That's true.
We did well as a result of COVID in a lot of ways with overnight visitorship, and that's certainly softened in the last 12 months.
Right.
So I would only suggest that we think about ways to, I know changing it back would be quite a heavy lift, but think about ways that we can continue.
Sorry.
Continue to support the folks who are, helping to generate that lodging tax back to the city.
Well, there's also like 3 or 4 more projects in the hopper.
Right.
That's gonna affect.
I'll tell you.
Tourism board was a really bad idea, in my opinion.
Okay, I'll tell you. So the Business Coalition from our own funds, right, through our membership fees, we're spending over $10,000 on marketing and advertising campaigns to drive people to Hudson just in the spring months.
Yeah, I mean, you're, got them.
Beyond that, we do advertising in both regional, and we're looking at now for the first time national magazines as well.
And so what's your point? The city should pay for that?
I'm
Well,
saying,
lodging tax.
Fine. No, I'm just good. I'm not.
So
Yes,
that the
it's respect-
businesses here make money and that the people can either rent.
If you could demonstrate that in some data.
Sure.
Like, it's worthwhile, but I just don't see it.
yeah, and I'm not saying that it has to come to it's meant to come to the coalition, but I think communities of all sorts make investments in marketing.
that was on the Beacon website, when I was looking at it, one of the cases that they made for increasing their municipal tax was specifically to use money to promote Beacon as a tourist destination.
The other objection that I have to more fundamental, that the DDA shouldn't be restricted. That money should not be restricted that way for future DEAs to be able to determine how to spend money. So let's say we do say, this 1% is gonna go to promote tourism, whatever that means. That kind of locks us into that. Rather than saying, come September, August, what will the DEA give towards whatever it is,
Mhm.
the lodging community thinks it needs.
Kind of like the events money,
That's
kind of like the events kind of.
Same way that sounds.
So,
And so, in other words,
if there is some, we could come with a proposal.
yes, that's what I think that's the proper way to go.
Okay, great.
Rather than a designation.
Sure.
And that has the other side too, people want this 1% to go to be designated for housing. I just don't see locking in the the way the BJ spends it, in the process of spending money in the city.
Sure, cause I see it to the point of time, like saying, cause the trends change, right? And the
Right,
needs
that's
change,
exactly.
right? Because again, be like, we need X amount of more parking because tourism kicking in, right? So it's like, oh, this year we need to do $10,000, right? Because tourism is increasing, we need more parking, our budget's not in there, right? So when you go to better to the need, especially because we know we're gonna get in a certain amount, right? So we have that to have people apply for, so every year could be something different, right? In terms of the need of the city,
Every time, if you designate the fund.
designated to.
A slush fund.
Put it in the, right, well, kind of,
I'm serious.
well, yeah, kind of a certain
Yeah.
fund that could do projects of need,
Right.
right? Because certain projects of need could change, tourism could
What's the
change, and we
need
might
of the
need,
year?
right, I mean, again, we might. More-
What's the need of the year? Like,
Yeah, that's what the BDA can do anyway.
okay,
Right, but the VA can do that, but have a certain amount of money to do it with, right? That 1%. Right?
Well, we can argue about it, but yeah, but then does it roll over? I mean, look what happened with the tourism board. It rolled over into that huge amount of money that, like, they didn't even know how to.
That money could have done it.
I know, it could have done a lot of things and it did
Yeah,
for all kinds of reasons, both
Yeah.
when there was a tourism board, and when there wasn't, I mean.
we got a nice trolley,
well, that would be great.
electric trolley.
Absolutely, that's, I never understood why they didn't come up with solutions like that originally. Instead, their first effort was to fund a huge marketing program.
Yeah, right.
So I want to bring us back. So I did not put any documents out for this because I don't think that the resolution already exists. It is going through the council. I think it probably came from Utah. So it's not gonna come through this meeting. I just wanted to make sure, like, it was taken off the agenda, just make sure everybody's aware of it. Look at whatever research you've been able to look at in terms of other municipalities in New York. And absolutely, I think getting input from the lodging community is important. If it's gonna be on the agenda next week, then that would be the time to weigh in, I think.
Definitely.
So do we, members of the public, anybody got their hands up? I don't think so.
I got something, Margaret.
Sorry?
For new business.
Okay, hang on, let me just see if there's any hands raised here. Yeah, go ahead.
So, wondering if we could, because it's early in this year, like, because, one of the things I think we should look at is the snow removal law.
Which?
The sidewalk, snow removal, I think that's a big issue for sidewalk clearing. In a timely manner. And I think that, I looked at Catskill, Catskill law is, okay, if you don't clean it, we're gonna clean it, and it's not a tax, it's a bill. Right, so we say every snowstorm, so every snowstorm, the landlord or homeowner gets a bill, if they don't clean it within a certain period of time, they get a bill. They get a picture of it, they take the picture, then they clean it, and then every snowstorm they send out. Now, if they don't pay, then of course they tack it on. So it's actually, a bill that gets submitted. I'm wondering if that's something we could do here, right? So it takes it away. So then one, it might encourage a landlord to say, listen, okay, I'm gonna go employ someone locally, contract them to do the work, rather than somebody else coming in and doing it and then charging whatever we charge, right? So I think we should really look at how we could turn that into something that, one, it can motivate landlords or property owners, whatever, to do their sidewalks in a timely manner. Otherwise, there's going to be different kind of enforcement that's going to be, again, even if we do a contract, I'm not saying DPW per se, but if you contract to a third party to do the work, they submit it, we submit it, and then they pay us.
So I think we can certainly look into that. I think the implementation and enforcement would be the problem.
Yeah.
Because it's very similar actually to, when we were looking at sidewalk law, when we were doing all of that. And I was researching different municipalities. So in New York City, If you are told that your sidewalk is defective, you're given a certain amount of time to fix it. If you do not fix it, you can either go with your own contractor or you can work with the city to have them do it. You do not do it, they do it, and they send you a bill. And so we looked at that and we looked at the fact that we have not been successful in enforcing sidewalk compliance. That wasn't working. And given that, I think, I don't disagree with the idea, but I think it would be very, very difficult to pull it off.
And create issues. They do it kind of selectively. After a snowstorm, they go around and they issue, notices. But that's basically, if you don't follow it, you get an appearance ticket.
And those tickets go away. My understanding is they go away. There's no,
Exactly.
the judge just throws it back.
So the question is how to change that into something more enforceable and
Enforcement was the bill, right? If you don't abide by
Yeah,
the 24 hours.
Okay, so here's the story. You sent me a bill. And
An
you had to pay the contractor. And I throw them away.
Right.
And now you've paid the contractor and no intention of paying.
Goes onto your,
You
leads onto your bill.
have to come up with a way to make it a lien on my taxes. Yes, you'd have to.
But that's what Catskill does. Catskill.
You'd have to bring a whole big machinery of complication.
I hit them up front with the penalty that, that's enforced, and one time, and they're doing what we're saying we're looking for them to
But the
do.
penalty would have to be enough that it's, cheaper to pay somebody to show you.
Just give them a ticket.
But that's the whole point. The ticket goes away because they go to court.
And it's been,
You can give them 5 tickets and it
it's
goes
not a
away.
ticket ticket, it's an appearance ticket, which can be dismissed.
Yeah.
That's the problem.
So we changed the ticket.
Okay, any other new business? No hands raised. Do we have a motion to adjourn?
I'll make that.
Do we have a second? Hey, great. Alex, thank you very much.
Thank you, everybody.